Colleagues, I also rise today to speak in support of Senator Boisvenu's amendment, which I believe to be carefully considered, thoughtful approach to proposed changes that have yet to be fully explained or justified. At the outset, I want to commend Senator Boisvenu for his continued dedication to the pursuit of justice, both inside and outside of this chamber. When it comes to the protection of victims of crime, Senator Boisvenu has always ensured that nothing falls through the cracks. Canadians are truly better for his passion, his tenacity, and his insight. Colleagues, Bill C-5 proposes to end a significant number of mandatory minimum penalties for serious offences. The merits of mandatory minimums and the role of Parliament in establishing sentencing parameters has been debated at length. While I personally believe it is not only appropriate, but indeed responsible for Parliament to set out mandatory minimum penalties on offences that impact public safety, I recognize that others do not share that perspective and view such stipulations as an infringement on judicial discretion. On this, I believe reasonable people can disagree. However, Senator Boisvenu's amendment focuses on a problem that has been identified by those most affected and most in tune with the experience of survivors of domestic and sexual violence. Bill C-5 proposes to allow for greater use of conditional sentence orders, such as house arrest, for a number of offences where the offender faces a term of less than 2 years of imprisonment. The offences eligible under this bill include sexual assault, kidnapping, human trafficking, assault with a weapon, and more. Women's groups and victims' advocacy groups, those who have real-world experience dealing with the ramifications of violent offenders post-release, have highlighted a glaring oversight of this proposal. Bill C-5 in its current form will allow for instances in which violent offenders serve their sentences from home in the same community as their victims. It can be right across the street, as was said, sitting in a lawn chair across the street. As this is a new proposal, we do not have any data on compliance with conditional sentence orders for these particular violent offences. However, Senator Boisvenu provided data indicating that a 44% failure to comply rate with existing conditional sentences. We also have data that demonstrates a stark increase in crimes against the person, specifically family violence, criminal harassment, sexual assault, and human trafficking. And the Senate's Legal Committee heard testimony about the experience of survivors of abuse when their abuser has been released on parole. The committee heard stories of intimidation, a lack of compliance, and a general feeling of unsafety among abuse victims, which would only be exacerbated by this expansion. Colleagues, while we all support the objective of rehabilitation, we also know that the best indicator of future behavior, colleagues, is past behavior. There is nothing in a conditional sentence that would protect women from a future violent attack. I raised this issue with Justice Minister Lametti when he appeared before this chamber for a ministerial question period. Unfortunately, as most of his answers, this one provided no explanation and gave skeptics of this proposal no comfort. In my question, I highlighted the testimony of Jennifer Dunn from the London Abuse Centre from her appearance at the House of Commons Justice Committee when she said, "Women and girls are 5 times more likely than men to be victims of sexual assault. And sexual assault is a violent crime on the rise in Canada. With conditional sentencing, many women will be stuck in the community with the offender, which places them at an even higher risk. I asked the minister, given the rising statistics, what message does it send to victims of sexual assault to extend leniency to sexual offenders through this measure? He answered me by saying, and I quote, "It will always be the case that serious crimes will attract serious penalties," unquote. We all know that this is, in fact, not the case, even under the current law. We can all point to examples of heinous crimes receiving shockingly low sentences, resulting in public outrage. However, given the minister's answer, I must ask, what could possibly constitute a non-serious sexual assault? Nobody has provided an answer for that. Not the minister, not the officials, not the sponsor of this bill. Senator Simons did try to draw a distinction between rape and what she considered to be a less serious type of sexual assault. However, there is a reason the offense of sexual assault is broad and encompasses a range of behavior, and that is because, as the Supreme Court states, sexual assault, and I quote, violates the sexual integrity of the victim. This is serious, colleagues. And regardless whether people in this chamber find that to be a laughing matter, sexual assault is, in all its forms, has the potential to cause serious, lasting trauma for victims, and our laws need to continue to condemn sexual assault in all forms. Colleagues, we must ask ourselves, what specific problem is this conditional sentence expansion seeking to fix? Some have cited the over-incarceration of Indigenous peoples as a justification for this measure. However, on that point, the committee heard no specific evidence that expanding conditional sentencing measures would have an impact on the Indigenous incarceration rate. In fact, criminology professor at the University of Ottawa, Dr. Cheryl Webster, and PhD graduate Don North testified on this specific misconception. While they wholeheartedly support the stated goal of prison reduction for Indigenous peoples, they cautioned that the data and multiple subsequent evaluations, in fact, demonstrate that the expansion of conditional sentence eligibility as a prison alternative has no meaningful impact on incarceration rates of Indigenous peoples. They further stated that there is, and again I quote, little reason to believe that the sanction will now contribute to significant prison reduction, especially for Indigenous people. Ms. North described the data in great detail, stating, "The research does suggest that even when conditional sentences are broadly available, Indigenous populations or offenders didn't proportionately benefit from them. There were instances when they were benefited, but it wasn't the same proportions as other offenders. There is also data suggesting Indigenous offenders tend to have a higher breach rate, even when they are granted conditional sentences. This becomes, of course, a problem for overall incarceration rates when they're imprisoned upon breach." Colleagues, if the reduction of Indigenous incarceration rates is the rationale for this expansion, it is not rooted in evidence, and according to researchers, could actually have the opposite effect when breach rates are considered. Not to mention, the data is clear that Indigenous women are at an increased risk for domestic and sexual violence. In fact, colleagues, more than 4 in 10, or 43% of Indigenous women, have experienced sexual violence in their lifetime. What benefit could it possibly serve an Indigenous survivor of abuse to have their abuser serving their sentence in the same community across the street? In my follow-up question to Minister Lametti, I asked what impact he believed this would have on a victim's likelihood to come forward, given that sexual assault is estimated to be the most underreported crime in Canada. The minister refused to answer the question. Instead, he used the opportunity to tout his government's record on helping victims of crime. Quite a rich retort from the minister who refused to appoint a federal ombudsman for victims of crime for 361 days, meaning that a year's worth of legislation impacting victims did not undergo this critical review. In fact, it would have served us well to have such a review on this legislation as we considered the impact on victims. While the minister did not have the answer, those who work with victims of sexual violence know exactly what is at stake. When Jennifer Dunn was asked about this at the Senate's Legal Committee, she indicated that she heard from a victim in her center's care that very day that she testified, who stated unequivocally that less protection and sentencing means less women coming forward, which would be a real setback for the fight against sexual assault. Senator Boisvenu is bringing forward this amendment, has carefully selected the offences which are most highly correlated with domestic and family violence, offences for which a house arrest in the community would pose the greatest risk to victims. Some senators at Legal Committee noted that criminal defense attorneys want this bill passed as quickly as possible, specifically the conditional sentence expansion. Imperfect as it may be, they said, because it would benefit their current clients. Colleagues, I submit that this is not a consideration we need to concern ourselves with. It is not our job to make sure that defense attorneys can ensure a better result for their clients. I recognize the important role that the defense plays in a fair and just trial. However, I have a hard time believing that many in this chamber would be rushing to pass imperfect legislation that would benefit the Crown in ensuring a harsher sentence for the offender. Rather than worry about which side of the courtroom this legislation helps, let's instead listen to the victims who have the experience to understand the real-world impact on this expansion. As one abuse victim in the care of the London Abused Women's Centre said, "It seems as if we are focused on the men that have created the problem and are not listening to the women who are on the other side as victims." Colleagues, the proposal to expand conditional sentence eligibility to perpetrators of violent offences is misguided. There is no data to suggest that it will impact the over-incarceration of Indigenous people. Yet it certainly will have an impact on the safety of abuse survivors, a category in which Indigenous women are tragically overrepresented as well. Please consider, colleagues, what is at stake for all the victims of sexual assault. Let's concern ourselves, colleagues, with the victims, not the perpetrators. And all other violent crimes against people. Let's listen to what victims are asking us and support this very thoughtful amendment. Thank you, colleagues.